Mr. Morales, I'd like to address you for a moment based on the comments made by your counsel. Sir, you do have a right to be heard, a right to allocution here at the sentencing proceeding, although you do not have to present comments to the court. Is it your decision to not present a statement to the court?
Yes, Your Honor.
Okay. All right.
Thank you, Your Honor.
You're welcome. Thank you, Attorney Gavin. Attorney Gavin, are there any additional statements or comments that you'd like to put before the court, in addition to I did take into the court record the certificates that you provided?
And I appreciate that, Your Honor. He's been incarcerated for over 5 years. He really has an absence of any disciplinary history. He's doing his best in there, and so we ask the court just to incorporate that into the ultimate determination. Thank you, Your Honor.
Thank you. All right, so at this time, I just want to point out again, the defendant has been convicted of murder and tampering with physical evidence by a 12-person jury. I did hear a plea to the court by defense counsel regarding PCP use. Intoxication was presented to the jury. It could have been relied on in terms of reaching that intent element of murder and tampering with physical evidence, actually. And the jury did move forward with convicting the defendant of murder and tampering with physical evidence. Now, in anticipation of sentencing, the court has reviewed the pre-sentence investigative report, my notes on the evidence, and the verdict. The court did hear the same evidence as the jury, and that evidence supports the verdict. In imposing sentence today, the court does consider a number of things, which the court will take the time to highlight for purposes of our record. The pre-sentence investigation report by probation, in which the officer recommends incarceration only. The court also considered the information contained in the pre-sentence investigative report, looking for mitigation. I will highlight some of the information from that report for the record. The defendant's age, now 48 years old and around 43 at the time of the murder, and tampering with physical evidence. The court has considered the defendant's family background as described in the PSI report, including the makeup of his family, his childhood experiences, and the relationship that he has with his mother, stepfather, and living brother. The defendant reports, and the court will acknowledge perhaps a difficult upbringing in that his father, who was killed when the defendant was 11, although nice to him, was apparently not so nice to the mother and older brother. The defendant reports his childhood overall as good, with ups and downs. His mother always has been supportive and loving. They do have a good relationship, and the stepfather has become his psychological father. His mother and father still support the defendant, believing in his innocence, although acknowledging their love for the victim and expressing the amount of suffering all family members are currently going through and have been going through for many years. The court notes that the defendant reports a history of PCP use back to 1993 with sober periods and periods of relapse, and a last reported use in 2019. The PSI also documents intoxication and marijuana use at an early age and the use of Illy back in 1994 before completing a 6-month drug program during a prior period of incarceration with outpatient treatment during a period of parole. The court will also note, however, that the court has no evidence in the trial, aside from the defendant's testimony, of any PCP intoxication at the time of the murder and the tampering of physical evidence in terms of laboratory results. So the evidence was limited to the testimony of Mr. Morales. With respect to medical and mental health of the defendant, the report indicates some childhood mental health therapy, limited treatment for anxiety, post-traumatic stress disorder as an adult, but nothing ongoing and no definitive diagnosis noted from any medical or mental health provider by the writer of the PSI report. The court has considered the defendant's work experience and educational background. It does appear from the report that the defendant did hold employment for some period of time prior to being incarcerated, and also that he did complete high school and started college with no degree. Court notes the defendant's prior criminal history, which includes domestic violence with a felony conviction for violation of a protective order in 2012, failure to comply with conditions of probation resulting in 2 violation of probations, and multiple felony drug sale related offenses with convictions dating back to 1996 and into 2000, which led to lengthy incarceration and lengthy periods of special parole. This court has carefully listened to the statements of Christine's Aunt Anna, Jody Jacobellis, Christine's brother's fiance, Christine's best friend, and Stephen Holloway, Christine's brother. I've also listened to the statement read into the record by Mr. Holloway from Christine's mother, and I have read the written statements that were provided to the court by way of the pre-sentence investigative report. I've considered the comments of the state's attorney, defense counsel. I've reviewed the certificates provided by defense counsel concerning the defendant's completion of certain courses and instruction during incarceration. I do want to acknowledge the difficult task it must have been for family members to give a statement to the court. Those statements were extremely emotional. I can't imagine how you feel, but I do recognize what you have been through over the course of many years to get to where we are here today, and the difficult task it must have been relaying how you felt to the court just momentarily. I want to let the record be clear of a few things. This court has not considered any statements or information provided to this court during this sentencing proceeding relative to any correlation between the defendant and missing child Vanessa Morales. The court recognizes its limited role in this particular sentencing proceeding on the guilty findings of murder and tampering with physical evidence. The sentence imposed will reflect the court's findings relative to solely those charges. I also want it noted for the record that multiple members here in support of the decedent have come into court today with T-shirts that depict the face of Christine Holloway. That is your right to do so. I did not preclude you from doing so, but I will note from the record that the court was not unduly influenced by that display on your apparel. Sentencing in a case such as this is a monumental task for any judge. The court must consider the goals of sentencing, which include, among other things, the court's obligation to impose a fair and just sentence, which enhances the public safety, holds the offender accountable, affects general deterrence in order to reduce criminal activity and promote rehabilitation. In doing so, the court also considers the seriousness of each offense and the facts established at trial. I'm not going to restate all the testimony and evidence that was presented during the trial of this case, and I do wish to spare the family members of any additional pain. However, I must comment briefly on the evidence that the jury heard for the benefit of any future proceedings. It was established beyond a reasonable doubt, our highest burden of proof, that the defendant specifically intended to kill and did in fact cause the death of Christine Holloway. It was further established beyond a reasonable doubt that the defendant intentionally tampered with physical evidence relating to the homicide of Christine Holloway. The evidence presented to the jury established that Christine was only 43 years old when her life was needlessly and violently taken from her at the hands of the defendant. This was not accidental, as the jury found, but rather intentional. It was a gruesome, intentional physical attack on Christine. The evidence that the jury heard included multiple blunt force injuries to Christine's head and neck, including skull fractures with a minimum of 8 blunt force impacts, leaving behind a horrific crime scene full of blood and brain matter and the lifeless body of a young mother, sister, daughter, co-worker, and friend. In lieu of calling the police or contacting anyone for help, the evidence presented to the jury indicated that the defendant stayed at the apartment, attempted to clean the bloody mess on the floor, discarded brain matter in a sink, and collected and discarded other evidence with blood on them at a donation box. In fact, bags of physical evidence, including children's toys splattered with blood, adult clothing, and other objects, all while leaving the lifeless body of Christine Holloway in a bathtub back at the apartment. Christine's body was left in a bathroom bathtub with candles lit and a skylight open. The defendant fled the scene. The defendant did take the stand in his own defense, telling the jury of drug use and unknown intruders, and how one of those intruders struck Christine multiple times with a crowbar and one took his daughter and ran out the door. A jury of 12 rejected his account of what happened to Christine, and the jury's findings are supported by the evidence. To the victim's family members and friends, thank you for your patience with this process, which admittedly has been extraordinarily long to bring this case to conclusion, and most certainly very difficult to endure. Although a conviction and sentence cannot bring back your loved one, I hope that it will provide some closure as to the investigation into Christine's death and open a path to the healing process, which I'm sure will be a lifelong process for many, if not all of you. I have heard through your statements and your letters to the court, which have provided a sense of life to Christine here in the courtroom. I understand how you feel today, how you've felt for many years, and you've given the court some indication of the type of person that Christine was. The impact of this crime, of the defendant's conduct within our society is profound. A vicious crime such as this severely impacts the overall feeling and safety in our society. Society should not have to fear such careless indifference to human life. It makes you question who really lives next door to you. Christine had the right to be safe in her relationship with her young daughter's father, safe in her own home. This was a cruel, intentional, senseless, violent act. The defendant must be deterred from ever committing such an act again, and the sentence imposed must reflect the court's intention to deter generally such violent, senseless acts from happening in our society. The facts of this case, along with your criminal history, Mr. Morales, leave this court to believe that you have no regard for the rule of law and a callous disregard for human life. Your record clearly establishes that prison sentences, probation, and special parole do not dissuade you from committing future crime. Any consideration to be given to the aspect of rehabilitation in this case pales in comparison to the severity of these crimes. Mr. Morales, you are a dangerous person, a significant threat to society, and you need to be removed from the community for a substantial period of time. The victim's family, as well as the members of society, expect the guilty to be held accountable for their actions and rely on the criminal justice system for some measure of closure. No sentence or comments by the court will lessen the profound sense of loss caused by your actions. But you, Mr. Morales, will be held accountable and sentenced accordingly. Mr. Morales, please rise.
Stand up.
Upon the court's considerations as outlined on the record, the following sentence is hereby imposed. As to the finding of guilty of the crime of murder of Christine Holloway, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 60 years to serve, which in accordance with our statutes is defined as life. As to the finding of the crime of tampering with physical evidence, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 5 years to serve, to run consecutive to the sentence on the murder for a total effective sentence of 65 years to serve. At this point in time, I'm going to note your right to appeal. I'm also going to note that Connecticut General Statutes 1898E does not render you eligible for risk reduction credits on the murder, that 60-year sentence imposed. You may be eligible, however, pursuant to our statutes, if applicable, to earn risk reduction credit on the sentence imposed on tampering with physical evidence. Total effective sentence, 65 years. The court is going to waive any costs and fees for good cause in view of the lengthy incarceration. You do have a right, sir, to seek sentence review and modification as provided by way of statute. As applicable, Madam Clerk will outline the documents she's providing you, which will also include a pardon brochure. Madam Clerk, would you please provide defense counsel and defendant with a copy of the documents, and please state on the record what documents you are providing.
Your Honor, we have executed the documents you're referring to and forwarded those to Madam Clerk for filing after the conclusion of today's hearing.
Okay, so just let the record reflect that the defendant is in receipt of his right to appeal, his conviction, his right to sentence review modification, as well as a pardons eligibility brochure. Counsel, is my understanding that there is property being held in this matter.
Your Honor, with the court's permission, we'd ask that all seized property be held pending the appeal.
As well as the fact, Your Honor, that there is an open investigation. So all property that was currently entered into evidence asked that it be maintained by the clerk's office for appellate purposes as well as additional investigatory purposes.
All right, the court will order the property be held for appeal purposes. The court wants to thank counsel for your professionalism in delivering your case and presenting your case to the jury during the trial and your arguments to the court of the sentencing proceeding, as well as your courtesies to one another. And I'd like to also thank the members of our audience for maintaining courtroom decorum during the trial and the sentencing proceeding. I appreciate that. Thank you. At this point in time, if there's nothing else.
There is two additional matters, Your Honor. I'm not sure if I know that there are costs. I'm not sure if the court entered orders with regard to that.
I did. Costs and fees are waived.
With regard to, there is a second file. It has been docketed today at my request. I will identify it as State of Connecticut versus Jose Morales. It is AAN CR 19-022-552T. This is a matter, 2 counts of criminal possession of an electronic defense weapon. This is a matter, it was an arrest effectuated by the New Haven Police Department during the course of the investigation. In this case, it was a matter that was pending in the New Haven Judicial District, and due to the fact that it was expected that this case was going to take a while, I agreed to accept jurisdiction of that case, and at this time, State is entering a nollie to both counts of those information based upon the sentence imposed by this court in the economy and administration of justice.
All right, so relative to that particular case, the court will go ahead and note the nollie. I am assuming due to the nature of the charges, there's also property in that case.
There is property. I would ask that those be destroyed.
No issue with that.
All right, court will go ahead and order the destruction of the property held in the case that was nollied. Is there anything else to be addressed by the court?
Not from us, Your Honor.
All right, thank you.
Thank you.
State?
I'm good, Your Honor. Thank you.
Court stands adjourned. Thank you.